In this lecture, we would like to discuss that those effects of alteration on the memorandum or articles of association of a company. So, as already we have discussed, the very alteration of memorandum of association of a company as provided under Section 13 and Section 61, Section 66, Section 48, Section 117, and Section 391 relating to the change of name of the company or alteration of the very objects of the company in the ADIC memorandum of association. And as regards to alteration of share capital, then reorganization of share capital, reduction of share capital, and creating reserve liability of a limited company, special resolutions of limited company, making liability of directors unlimited, and also regarding alteration of the rights of the holders of special classes of shares. So, would love want to discuss the very effects of alteration on the memorandum or articles of association of a company. So, notwithstanding anything in the memorandum or articles of a company registered under the register of companies, no member of the company shall be bound by an alteration made in the memorandum or articles of association after the date on which he became a member. So, the very alteration of memorandum of association and articles of association would only be applicable to those existing members, not to those members after alteration in the memorandum or articles of association became a member of the company. If and so far as the date on which he became a member. So, in regards to that, alteration requires him to take or subscribe for more shares than the number held by him at the date on which the alteration is made, or in any way increases his liability as at that date to contribute to the share capital of or otherwise to pay money to the company. So, all the existing members of the company, when it is registered under the register of the companies, if any alteration is made, it requires him to take to subscribe for more shares than the number held by him already at the date on which the alteration is made, or in regards to any way increasing his liability of the existing member of the company already registered at the register of companies to that date, and also to contribute to the share capital of or otherwise to pay money to the company by the existing member in regards to any alteration made on the memorandum or articles of association. But this will not be applicable to Thus, if the members agree in writing either before or after a particular alteration is made, to be bound by the alteration. So, any such agreement made in writing either before or after such alteration is made by the company, that they would not be bound by that alteration, then it would be applicable. So also, in any case where the company is a club or the company is any other association and the alteration requires the member to pay recurring or periodical subscription or charge at a higher rate, although he does not agree in writing to be bound by the alteration. And as this very provision we found under Section 10 of the Companies Act 2013, that in certain circumstances, that where the company, if it is particularly registered under the register of companies as a club, or the company if it is registered as any other association, and if any alteration is made by the company, such alteration requires that member already existing as a member in that company which is already registered under the register of companies to pay recurring or periodical subscriptions or charges at a higher rate. So, in regards to that, even though such member does not agree in writing, he would be bound by the very alteration made by the said company, even though he was an existing member when the very company was registered. But it would be only applicable to the club, those which are registered under the register of companies, and also to those companies and any other associations. So, as it is provided under Section 10 of the Companies Act 2013, so almost we have discussed some important concept relating to corporate law, and in particular in Indian context, the Companies Act 2013 in relating to what exactly debenture means. As already we are all conscious about debenture in this ultra modern context, almost most of the citizens and public are associated with debentures, and they contribute the very debt and loan received by a company through debentures. So also we have discussed regarding what exactly share means and share capitals and stock, etc. And these are also very commonly and universally known concepts in the modern business world. So also in context of the share market, and also in regards to the very provisions relating to stock exchange. So, in the context of stock exchange in relating to debenture and share capitals, as we are habituated and also acquainted with the international stock exchange like the New York Stock Exchange or the Shanghai Stock Exchange and also the Bombay Stock Exchange and the National Stock Exchange in relating to share and share capital. So also, we have discussed certain important common concept and those are running and in the present and in some way also in the recent past in regards to merger and amalgamation of the companies such as small companies to or more small companies and also the holding companies and associated holding companies or subsidiary companies. And that also in the context of India we could like to refer the very example of State Bank of India when its subsidiaries were merged and amalgamated such as the State Bank of Hyderabad, that is an associated bank of State Bank of India, and also the State Bank of Maharashtra, which was also an associated bank of State Bank of India, so also the State Bank of Mysore, which was also an associated bank of State Bank of India, and many such, also the State Bank of Patiala. So almost many such associated banks of State Bank of India, they were merged and amalgamated with the State Bank of India. So there are many such instances in the public sector and even in private sector in relation to merger and amalgamation of two or small more companies and also the holding companies and the subsidiaries holding companies. So almost we have touched some modern developments in regards to corporate laws in connection to private and public limited companies in connection to their debentures, shares, share capital, amalgamation, and in regards to any alteration of their memorandum of associations and articles of associations as per the very provisions of the Companies Act 2013. So also we have discussed in regards to the very rule developed, that is the rule of indoor management and how it is an exception to the doctrine of constructive notice as provided under the Companies Act 2013. So almost we have touched certain recent and modern concepts which are popular in the business circle among the investors and in particularly the provisions relating to the Companies Act 2013, which are very common among the investors, so also among those companies of public limited or private limited. And in that context, almost we have discussed not only regarding debenture shares, so also regarding alteration of memorandum of association, articles of association. So also the very important concept that developed in the English law, that is relating the rule of indoor management and how under the Companies Act 2013 it is an exception to the rule of constructive notice that was found under Section 399 of the Companies Act 2013.